Most homeowners assume that if a rule exists, it must be legal. That assumption is exactly what allows many homeowners associations to enforce restrictions that quietly cross legal boundaries. HOA rules are often written in formal language, distributed in official-looking documents, and enforced with confidence. Over time, that presentation creates an illusion of authority. People stop questioning whether the rules are valid and focus only on whether they are being followed. That illusion is powerful, and it is rarely challenged. The first time I realized something was wrong, it was not because a rule felt unfair. It was because it felt absolute. The HOA insisted that a specific restriction applied to everyone, without exception, and that there was no appeal. The language used in the notice left no room for interpretation. It did not reference community standards or best practices. It referenced obligation. That alone raised questions. HOAs are not governments. They are private entities created by contract. Their authority comes from governing documents and is limited by state and federal law. They cannot override statutes, discriminate against protected classes, or impose penalties that exceed what the law allows. And yet, many HOA rules do exactly that. One of the most common examples involves fines. Many associations impose fines automatically, without hearings, notice periods, or an opportunity to contest the violation. Homeowners are told that fines will continue to accrue until compliance is achieved. The problem is that in many states, fines are not legally enforceable unless specific procedural steps are followed. In some jurisdictions, HOAs are not allowed to levy fines at all without court involvement, but the fines are still issued, and people still pay them. Another common category involves access and entry. Some HOA rules claim the association has the right to enter private property at any time for inspections or compliance checks. These rules are often enforced casually, as if they are routine. In reality, unrestricted entry without consent can violate trespass laws unless a true emergency exists or access rights are clearly and narrowly defined in the governing documents. Many HOAs stretch vague language into blanket permission, counting on homeowners not to challenge it. Parking rules are another area where legality and enforcement often diverge. HOAs frequently impose restrictions on street parking, guest parking, or vehicle types, even when those streets are owned and regulated by the city. In such cases, the HOA has no authority to regulate public property, but enforcement continues anyway, often through warnings, fines, or towing threats that appear legitimate but have no legal foundation. Then there are rules that conflict with federal protections. Restrictions on flags, satellite dishes, solar panels, or religious displays are common. Many homeowners are unaware that federal and state laws explicitly protect these items. HOAs may still attempt to limit or ban them outright, using outdated rules or broad architectural guidelines. Enforcement persists until someone pushes back with legal citations. Selective enforcement is another quiet violation that often goes unnoticed. HOAs are required to enforce rules consistently. When a board targets specific homeowners while ignoring identical violations by others, it can cross into illegal discrimination or abuse of authority. The rule itself may be valid, but the way it is enforced is not. Proving selective enforcement requires documentation and patience, which is why many HOAs rely on the assumption that no one will bother. What makes these rules particularly dangerous is not just that they exist, but that they are enforced confidently. Letters are sent. Deadlines are set. Penalties are threatened. The language is authoritative enough that most homeowners assume resistance is futile. Over time, illegal rules become normalized simply because they are never challenged. The deeper problem is that HOA boards often do not fully understand the limits of their own authority. Board members are frequently volunteers with little legal training. They rely heavily on management companies and template documents. When those templates are outdated or overly aggressive, illegal provisions slip through and remain in force for years. Once a rule is written and enforced without resistance, it gains momentum. New board members assume it is valid because it has always been done that way. Management companies enforce it because it exists in writing. Homeowners comply because they believe they have no choice. The system sustains itself through silence. It is only when someone stops accepting authority at face value and starts asking where that authority comes from that the cracks appear. Illegal rules do not collapse on their own. They persist until challenged, documented, and confronted with actual law rather than internal policy. And that challenge usually begins with a single uncomfortable question. Where, exactly, does this rule get its legal power? When homeowners finally challenge these rules, the response from the HOA is rarely immediate or transparent. Instead, there is almost always a period of deflection. Boards claim misunderstandings. Management companies point to governing documents without citing specific legal authority. The goal during this phase is not to prove legality, but to delay confrontation long enough for pressure to do its work. The first real shift happens when a homeowner stops arguing about fairness and starts asking for legal justification. Not opinions, not tradition, actual statutory authority. At that point, the tone of enforcement often changes. Confident language becomes cautious. Deadlines quietly disappear. Violations stop escalating. This is not accidental. Many HOA rules survive only because no one has ever forced them to exist outside internal paperwork. The moment a rule is placed next to state law, federal regulation, or municipal code, its weakness becomes obvious. Boards know this, even if they do not say it out loud. That is why enforcement often collapses the moment legal citations appear in writing. One of the most common outcomes is selective retreat. The HOA does not formally revoke the rule. It simply stops enforcing it against the person who challenged it. Letters stop arriving. Fines stop accruing. The issue fades quietly. This allows the board to avoid admitting wrongdoing while preventing a public precedent that others might follow. In some cases, however, the conflict escalates. When a homeowner continues to push for formal acknowledgement, the HOA may be forced to involve legal counsel. This is usually where reality intervenes. Attorneys are far less willing to defend rules that clearly conflict with statute. Advising a board to continue enforcement of an illegal rule exposes both the association and its directors to liability. At this stage, the language changes again. Rules are described as guidelines. Enforcement is reframed as discretionary. What was once mandatory becomes flexible. This reframing is not an admission, but it serves the same purpose. The financial consequences of illegal enforcement can be significant. HOAs that impose unauthorized fines may be required to refund collected amounts. Improper towing or property interference can expose associations to damages. Discriminatory enforcement can trigger civil rights claims. These risks are rarely discussed with homeowners, but boards are acutely aware of them once a challenge becomes credible. Another important consequence is procedural reform. Once an HOA is confronted with legal limits, it often tightens its processes. Notices become more formal. Hearings are scheduled properly. Documentation improves. This is not done out of goodwill. It is done to reduce exposure. Interestingly, the greatest impact is often indirect. When one homeowner successfully challenges an illegal rule, others begin to ask questions. Past enforcement decisions are re-examined. Rules that were once applied casually become politically risky. The board's authority becomes conditional rather than assumed. This is why HOAs resist transparency. Transparency invites comparison. Comparison invites scrutiny. Scrutiny invites accountability. Illegal rules thrive in environments where decisions are fragmented, communication is limited, and homeowners are isolated from one another. It is also why management companies play such a critical role. Many illegal rules originate not from malicious intent, but from recycled templates that are never updated to reflect current law. When those templates are enforced without review, they become operational policy. Challenging them forces both the board and management to confront their own lack of oversight. There is a common myth that HOAs are legally untouchable. That myth persists because most disputes never reach a point where legality is tested. Homeowners comply, sell, or disengage long before a rule is forced into a legal forum. But when that forum is reached, the power imbalance often reverses. Illegal HOA rules do not survive litigation well. They rely on intimidation, not law. They rely on silence, not precedent. Once exposed to formal scrutiny, they either collapse or are quietly abandoned. The most important lesson is this: enforcement does not equal legality. Just because a rule exists on paper, and just because it has been enforced for years, does not mean it is valid. Authority must be grounded in law, not habit. HOAs function best when their power is limited, transparent, and accountable. When those limits are ignored, enforcement becomes abuse. And abuse persists only as long as it goes unchallenged. Most homeowners will never challenge an illegal rule. That is precisely why those rules continue to exist. But the moment someone does, the system changes. Not loudly, not dramatically, but decisively. And once the illusion of absolute authority is broken, it rarely returns.